Good afternoon. My name is Tracy Burns. I am the CEO of the Northeast HR Association. I have with me today Jeff Siegel of Morgan, Brown & Joy. He's a partner there. And our podcast this afternoon is going to focus on the newly released regulations for the Fair Labor Standards Act. Thank you, Jeff, for joining us. I'm sure that your office has been really busy in the last few weeks, if not months, trying to tackle this issue with your clients. So I appreciate you carving out a little bit of time for us to be able to talk about this. We are just going to spend a few minutes today sort of talking about, Jeff will give a highlight of the regulations I'm sure most people have already seen, if not a highlight, some deeper information about this. And we are having a webinar that will be a full hour on June 27th. So you can learn a lot more detail about that. The purpose of this podcast is just to do a really high level overview and sort of talk about even what's transpired in the last couple of weeks since the regulations dropped. So Jeff, I'd like to just get started if you could just highlight what some of the major changes are, that would be great. And then we'll talk a little bit about what you're hearing from your clients.
Sure. Thanks, Tracy. And thanks for having me and letting me speak to you and your members. The highlights is I'm sure everybody has seen, or a lot of people have seen in their inbox from various sources, as the Department of Labor has updated the salary level required to be considered exempt from overtime under certain exemptions under the Fair Labor Standards Act. The last time they updated it was back in 2004. As of December 1st of this year, that the number for a salary level test is going to increase from $455 a week to $913 a week, which basically means if you're an employee making less than $47,000 a year, you are unlikely to be exempt. There are some exceptions to that, of course, but that's the biggest takeaway. There are some smaller takeaways from the new regs that the membership should be aware of. The highly compensated employee salary threshold is going to increase from $100,000 up to $134,000. Importantly for everybody, these increases aren't just a one-time increase. The way that the rules have come out is every 3 years, the Department of Labor is going to automatically adjust the numbers again based on an index of what a salaried worker should make in their estimation. Of course, we expect that number is going to go up every 3 years, but it's still scheduled to be adjusted. And then the last piece is that the Department of Labor has changed the rules a little bit about when a bonus can be considered when determining whether somebody earns $913 a week. All of those changes go in on December 1st of this year.
Great. So what are you hearing? I think that if I remember correctly, maybe the last week in May, they sort of were made public. What are you hearing from your clients now in terms of, both their level of understanding, but more importantly, where some of their concerns might be in order to be able to get from where they are now to where they need to be on December 1st?
Yeah, so these, by way of history, these changes were announced in concept last year. There was a proposed rule that was issued earlier, and then you're right, in May, they came out with what is going to be the final rule. Other than a little bit of groaning that I've heard from the clients, there is an understanding that these numbers had to change because they hadn't changed in so long. And so now what a lot of clients are addressing is, okay, how do we work within our budget to make sure that employees are either meeting the test, or if they're not going to meet the test under this new salary, how do we budget for the overtime, and how do we account for the work that needs to get done? And there are a number of strategies they're using to address that, changing the rates of pay, changing the way people are paid. As you can imagine, there are a number of different ways to sort of financially address how these change in pay practices are going to be. But fundamentally, what the Department of Labor has done here is they've made, according to their estimates, about 4 million workers now overtime eligible that weren't before. And so there's no one easy way to address all of those issues. So I think it's just a matter of trying to figure out in your budget, how are we going to pay them, and how are we going to make sure that we have the money to do it and accounted for it?
Right. And we did a panel with some of your colleagues a couple of weeks ago, and one of the themes that came out around that from an HR perspective was also just how to have these conversations with employees who might feel as though they're taking a step back and or potentially losing some benefits to the extent that employers are still lining up, benefits with exempt versus non-exempt, which I think, is probably not as common and hopefully not as common as it used to be, but certainly in some environments, I'm sure that that's still the case.
Yeah, no, that's a really good point. One of the impacts of this change in the law is a number of individuals at companies are going to go from having salary, which a lot of people view as a status symbol, to being hourly, which a lot of people view as having less status. The irony being is the Department of Labor has done this so people can get paid more. That's the idea behind it. But it has a different sort of emotional impact. And so having that conversation first internally, educating the executives on this is what the change means, and this is who we have to look at, and these are the decisions that we have to make. And then after that, knowing how to communicate that to employees. And a lot of employers are using this as an opportunity to revisit the way that they pay people. I mean, the exemptions under state and federal law are very complicated, and they're hard, and reasonable minds can differ as to whether somebody is exempt or not. And so these regulations are also acting as a convenient point in time to go back and see, okay, is this person really exempt? And if they are, let's keep them to be paid on a salary basis. And if they're not, we're going to use this as an opportunity to transition them because we have to address other employees anyway.
Yeah, it's a really great opportunity to sort of leverage, what has to be done already in order to maybe realign things and come more into compliance without it feeling like it's just something that we're doing, but we have to. So, any sort of resources that, obviously, Morgan Brown and Joy is a great resource. Any other resources or websites? Because even as you mentioned in the beginning, a lot of us are sort of inundated with, this information in our mailboxes in the last couple of weeks. And I'm wondering if you have any of your favorite resources, that whether websites or other places that people can go to sort of, maybe get direct information.
Yeah, no, and there are a lot of third-party sites out there, you're right, who are attempting to synthesize and provide this information, including Morgan Brown and Joy and other law firms. But if the membership takes a look at the Department of Labor's website, they have some very good nuts and bolts explanations for what the changes are. I think the Department of Labor's website is, attempting to paint these changes in a certain light. But in terms of what the fundamental change in the law is, that's very good. And that's at dol.gov. And then if you click through the featured areas into the overtime area, there are a number of Q&A sheets. There are a number of fact sheets that lay out what the exemptions are, that lay out what the changes are going to be, and some strategies, broad brush strategies on how to address them.
Yep. So I'm going to ask you a question that's probably not fair, and I realize you probably might be biased on this, but do you think that the average employer can go through this process without the help of an attorney or outside counsel of some sort?
Anytime you talk about wage and hour law, it's dangerous. And it's dangerous because wage and hour law inherently has enhanced penalties for employees. On the state side, there's mandatory triple damages. And on the federal side, there's also multiple damages available. So you're right. I, of course, am biased and will tell you that your friendly neighborhood employment lawyer is the person to whom you should speak. But a lot of small businesses choose to address this in different ways, whether through a consultant or whether just through a payroll company or trial and error. I think that's a risky strategy, but there are resources like the Department of Labor out there that will give people the general guidelines of what they should be looking for.
Yep. Great. Yeah. And I would echo those sentiments, having gone through it myself and having been an HR professional, that it's worth any short-term investment that you might need to make in order to make sure that you do this right, because the penalties are big, not to mention the headline risk and all the internal headaches. So it's better to get it done right. And there's a lot of, you guys I know are offering different workshops, and as are other organizations across the New England area. So there's plenty of opportunity to learn how to do stuff and then to make connections with, whatever appropriate firm or resource might be worth it. So Jeff, thank you again. Time goes by quickly, so we're already almost at close, but I appreciate you taking the time to do this with us today. I know I'll just mention again, the full webinar will be on Monday, June 27th from 1 to 2 p.m. Eastern Standard Time. It's free for any members, and I think there's a nominal fee for non-members. But if you need more information, that's another great way to do that in a couple of weeks. You can register on our website at NEHRA.com, and we'll see you again next month.
Great. Thanks for having me.
Thanks, Jeff.